Good afternoon, everybody. Ani, Bojo, Nangosa Gusha Nadeshnakas. I'm Susan Hare. I'm an elected bencher with the Law Society of Upper Canada. And on behalf of the Law Society of Upper Canada, thank you to all of you who are joining us here for today's program. I'm an Anishinabek lawyer from Chiging, Ontario, and I acknowledge the Mississaugas of the New Credit First Nation. I also acknowledge the Haudenosaunee of the Six Nations of the Grand River. Today is the Law Society's 15th National Aboriginal History Month Public Education Equality event. This event is one in a series of free public forums that the Law Society hosts throughout the year to encourage the exchange of information, ideas, and action on legal issues relating to the rights and legal needs of Aboriginal peoples and equality-seeking groups. The program reflects the Law Society's ongoing commitment to enhancing the inclusion of members of the equality-seeking communities in the legal profession. We are really pleased to host today's event in partnership with the Chiefs of Ontario. We have a very full program this afternoon, and to maximize my time, I'm going to keep my remarks short. You have been provided with biographical information on the panelists who are on our agenda and who sit to my left. At the end of the panel discussion, there will be an opportunity for questions from the floor. There is a standing microphone in the audience for that purpose. There's two of them, actually. In consideration of other audience members, we ask that you limit your questions to single queries. As well, we request that you respect the diversity of opinions presented today and formulate your questions to encourage constructive discussion. Before you leave the Lamont Centre today, please fill out the evaluation sheet included in your materials. We appreciate your feedback and are always working to improve our public education equality events. We have a surprise guest today, Erwin Glassberg. He's the Assistant Deputy Attorney General and co-chair of the Yakabuchi Report Implementation Committee. Because of his involvement with the committee and the importance of the issue of jury selection and access to justice for the Aboriginal community, we have asked Mr. Glassberg to provide a very brief update on the activities of the Implementation Committee. Please join me in welcoming Erwin Glassberg.
Thank you for that kind introduction. Good afternoon, and thank you for providing me with the opportunity to speak with you at this important event. My name is Erwin Glassberg. I'm the co-chair of the Jury Review Implementation Committee and an Assistant Deputy Minister at the Ministry of the Attorney General. I would like to acknowledge that this meeting is taking place on the traditional lands of the Mississaugas of the New Credit First Nation. I would also like to thank the Chiefs of Ontario and the Law Society for co-sponsoring this public education event to celebrate National Aboriginal History Month. Finally, I would like to send greetings from my co-chair, Deputy Grand Chief Alvin Fiddler of the Anishinabek Nation. Although this conference will deal primarily with land and resource issues, I have been asked to provide you with a status update on the review of the work of the Jury Review Implementation Committee. This group has been dealing mostly with criminal law issues and how to build respectful relationships in the justice sphere between government and Aboriginal peoples. Let me first provide you with some background on the formation of the Implementation Committee. In August 2011, then Attorney General Chris Bentley announced that he had asked the Honourable Frank Yakabuchi to review the process for including individuals living on First Nations reserve communities on the province's jury rolls, and to make recommendations on how to enhance such representation. In February 2013, following extensive consultations, Mr. Yakabuchi released his report entitled First Nations Representation on Ontario Juries. The report made 17 recommendations in 5 main areas or themes: establishing an implementation committee and a minister's advisory group, addressing systemic concerns about the justice system, reforming the jury role and selection process, jury member compensation, and coroner's inquests. On the same day the report was released, former Attorney General John Gerritsen publicly committed to address the report's two threshold recommendations: the appointment of the Implementation Committee and the creation of an advisory group to the Minister to consider broader matters affecting First Nations and the justice system. Following extensive outreach to Aboriginal organizations in June 2013, the Minister announced that Deputy Grand Chief Alvin Fiddler and I would be appointed as co-chairs of the Implementation Committee. In September 2013, the first Implementation Committee meeting was held. At the same time, the government announced the membership of the committee. The members selected have a wide and diverse background. They are Elder Barney Batiste, the Honourable Irwin Stack, former judge of the Superior Court of Justice, the Honourable Mark Bode, Regional Senior Justice, Northwest Region, Ontario Court of Justice, Margaret Froh, lawyer and former president, Indigenous Bar Association, Diane Kelly, lawyer and former Grand Counsel, 3D3 Grand Chief, Jenny Ristul-Malozzi, counsel, Union of Ontario Indians, Alison Pila, Assistant Deputy Minister, Ministry of Aboriginal Affairs, Sheila Bristow, Director, Court Services Division, and Megan Logan, a Georgian College student and the committee's youth representative. Since inception, the committee has met on 9 occasions at various locations across the province, including Toronto, Manitoulin Island, Thunder Bay, and Kenora. Committee members consider community consultation to be a critical part of the process. In that respect, each 2-day meeting typically includes a component open to the public as well as an open house. This enables members of the community to share their experiences with the justice system, talk about their priorities, and respond to questions posed in advance by the committee. The Implementation Committee has developed a detailed work plan and is proceeding diligently to provide advice to the Deputy Attorney General. The items that have received active discussion to date include following items: establishing community liaison officer positions to enhance Aboriginal participation on juries, creating a new executive position in the Ministry of the Attorney General responsible for Aboriginal justice, creating opportunities for law students to work in Aboriginal communities, examining the potential usefulness of different government databases to increase participation on juries, considering how to improve the wording in jury questionnaires, and organizing a youth justice legal conference. Committee members are working well together and sharing their different perspectives. Non-Aboriginal members have also received cultural training on Aboriginal traditions, customs, and the Aboriginal worldview. Everyone recognizes the need to make steady progress on Mr. Iacobucci's recommendations while also ensuring that they respond to the actual needs of Aboriginal communities. Recently, the committee has changed its name to Debwewin, Jury Review Committee. Our elder advises us that the word Debwewin is an Ojibwe term meaning truth. Truth has 2 dimensions for the committee: the search for truth and the trueness and integrity of its advice. When thinking about the work we have done together with Aboriginal partners in the last year or so, there are a number of important lessons that we've learned and that I would like to conclude on. For me, these are that working in genuine partnership with Aboriginal peoples is key to making meaningful change on public policy and program issues. The Jury Review Project presents a unique and timely opportunity to advance the way Aboriginal peoples and government work together and how each perceive and experience the justice system. It shifts the dialogue from an us versus them to a we dialogue. Trust is hard to gain, needs to be earned, and is easily lost. To build trust, there is a need to continuously engage with the community. Taking the time to do things right is more important than just getting things done quickly. There is a need to respect the decision-making autonomy and style of Aboriginal members. and we in government need to be careful not to frame issues prior to engaging in respectful conversations with our Aboriginal partners. I would be pleased to provide further updates as the work of this committee proceeds, along with the companion Aboriginal Justice Advisory Group. Thank you for giving me the opportunity to speak to you today and present this short update, and I hope you have a worthwhile and interesting conference. Thank you.
Thank you, Mr. Glassberg. Our panel discussion today is on the Keewatin lands decision and what could its impact be on the future of Aboriginal interests and resource development. I am now going to ask John Beaucage, former Grand Council Chief for the Anishinabek Nation and presently partner with Council Public Affairs, to start off our presentations. He will be setting the stage for our panel discussion on the intersection of treaties and resources development on First Nations land and with First Nations in Ontario. Mr. Beaucage.
Thank you very much, Susan, and thank you all for being here to take part in understanding some of the history of our place in North America here, and as Mr. Glassberg mentioned, Aboriginal worldview, which also is very, very important. I'm going to touch on that with my talk. First of all, I do want to acknowledge, once again, like the people before me, the Mississaugas of New Credit and their traditional territory upon which we are holding this meeting. Thank the Chiefs of Ontario and the Law Society of Upper Canada for this event. In looking at Aboriginal worldview, I do have to go back. I have to go back in time a bit, and I'm going to go back to 14,000 years ago to bring some of the aspect in perspective of our worldview. And as many of you may know, 14,000 years ago, there was an ice age, and North America was pretty much covered in ice. There was this land bridge between North America and Russia and Asia, that kind of thing. Well, back then, my forebears got together, probably somewhere in BC, could have been in Alberta or wherever, over that part of the country, and they decided to get a whole bunch of volunteers to go over that land bridge, to go that way and help populate Asia. That was one of our tasks that we set upon ourselves. The Creator said that we have to go out and proliferate the world, bring our genetic material all over. So we did. We helped populate Asia. It wasn't the other way around, as you often hear. So there's part of Aboriginal worldview and a particular point in history. Another point, in between the 10,000 years ago and, say, 500 years ago, we had a great trading nation here in North America. We traded right from the far north down as far as the warm seas. We traded from where the orca swam right over to where there was Atlantic salmon. We traded everything. We traded feathers, we traded copper, we traded meat, we traded fish, we traded specific goods that were too innumerable to discuss. We traded, we had treaties amongst ourselves, we had spirituality, we had vast societies, we had not cities, but villages and towns. And North America was quite a vibrant place. And then about 500 years, well, actually even before 500 years ago, about 8,000 years ago, we had a huge gathering at the Hopi Nation in the center of North America. All of our spiritual people gathered, and they gathered for a whole summer, and they talked about things to come. They talked about, well, they had ceremonies. They had shaking tent ceremonies. They had sweats. They had fasts. They had feasts. They had powwows. They had dancing. But all these people gathered together to talk about a change in the world. They recorded their discussions on some of the rock faces in Arizona. They talked about a change that was going to occur in this world, that there was going to be a white cloud that was going to come across North America from east to west, and then later on from west to east, crushing us in the middle. And we had to prepare, we had to do something about this. So our spiritual people went back home and they started preparing. We had a great migration about 1,000 years ago from the east coast into the central part of North America. And part of that migration was to carry our stories, our songs, our language, our spirituality, and guard it and protect it, because it was going to be under fire, it was going to be attacked. Then about 500 years ago, this white cloud landed on the east coast. Unfortunately, we had a very poor immigration policy. We let anybody in. And we're paying for it now. But be that as it may, we were down at the shores and we welcomed these people. We shook their hands. We fed them. We put a roof over their heads so that the harsh winters wouldn't kill them. We looked after them for the first 200-300 years. And then people became too numerous for us to look after. And they started looking after themselves. And then they decided, well, there's all this land out there. You know, maybe we should make a treaty with all these people here, and in that way we can take their land and we can take their resources, and we can buy Manhattan for a couple of pots and some copper kettles and a few beads. And meanwhile, the Anishinabek guys that got these copper pots and beads and metal implements that they could use to keep life going, they said, you wouldn't believe it, these guys figured that they could buy this land. Nobody could own land. You can live on it, you can use it, but you can't own it. I may as well tell them I'm going to sell them my breath, because you can't do that. So we really pulled a fast one on those white guys, didn't we? And that was the thought, that's worldview, understanding of what was there. Well, the treaty process did happen. We agreed to share. But part of that treaty process was that, okay, we're still small, we're just having these little villages, we're going to cut down a few trees, we're maybe going to dig some holes in the ground here. But all that other land out there, all of it, well, as far as you can see, you guys can still hunt and fish and gather, and we're not ever going to stop that. And then land started to be patented. And every time a piece of land was sold, whether it be 1 acre or 100 acres or 1,000 acres, that was land where our treaty rights were not recognized, where we couldn't hunt, where we couldn't fish, where we couldn't gather. And this has been going on now in some places for more than 200 years. Where we're standing right now, probably 150 years. And we give acknowledgement and homage to the Mississaugas of New Credit for this land that we're sitting on right now. Well, at one time, the Mississaugas could walk anywhere here. They could plant a field. They could go down to the lake and fish. They could do all of these things, but they can't now. They can't. And every time another piece of land is sold, that's another resource that has gone from us forever. And so when we look at resource development, when we look at consultation and accommodation, it's not just the now that we're looking at. And in my own heritage and our heritage, I see many Anishinabek people around the room here. We are taught to think in 7 generations. So whatever we do now, we have to make decisions 7 generations hence. And then each generation does that. So you're always thinking way ahead. So when you have development in the here and now, it's not the here and now that we make the decisions for. It's the 7 generations ahead that you make that decision. And I've been involved in transmission lines, I've been involved in forestry, I've been involved in power development. I've done some mediations and facilitations of pipelines. Development companies and corporations always are looking at the here and now. CEOs are always looking at the next quarter. Are we going to have some profit the next quarter? Is there going to be enough money in for shareholders in the next quarter? Governments, they look to the next election. Am I going to do the right thing now so that my party can be elected in 4 years' time? And then when we are engaged to talk about development, everybody wants to say, well, this is what we've got on the table. Let's make a decision now. And it doesn't work out that way, because we have to think about it. We have to consult our elders. And then in some cases, we have to have a ceremony where we not only consult our elders and the people that are in the here and now, but we consult the people that are in the spirit world. Those spirits that have gone on before and those spirits that are yet to come, because they're all there in the spirit world. And then during the ceremony, we ask them the questions, because the decisions that we make are for 7 generations. And we're not going to make it quickly. If you want a signature on that page today, forget it. We're not going to do it. But we are going to think about what we can do for our communities, how we can do it for our communities, and what's best for our communities. And not the here and now, but for the 7 generations as well. So when we start looking at the mix of the corporate world, the legal world, the government world, with our world, sometimes it can be like mixing oil and water. It doesn't mix. That there's still some cultural, societal, spiritual, and legal divides. And much of the work that is being done by good people to more define these things is helping us all. We know where we're coming from. We know what our rights are. We know that we've been here since time immemorial, and that the Creator has given us a task to accomplish while we're here. But that pales in comparison to the bigger picture that we see as being important with every decision that we make. We applaud every legal decision that happens. We applaud all of these things that are going on because they help define what's going on. But also, I think that we need to ratify some of these things within ourselves in terms of how we deal with developers. And I'll give you an example of something that I'm working on. I'm working on a large wind power project here in Ontario. And the community decided over 6 years ago that they wanted to get involved in renewable energy. We've been working on this thing for 5 years, and we've been putting together $1 billion project with chewing gum and baling wire for 5 years. We have a power purchase agreement from Ontario for a 20-year power purchase agreement. We've gone through, we're on our third developer right now, because the first two weren't able to look after all of the needs of the project and understand how First Nations work. This last developer that we're working with has been just phenomenal. And today, our corporate entity got $1 million in the bank. We've been working for 5 years, and nobody's been paid on this. Even some of the engineers, even some of the lawyers. But today, everybody was smiling. And we are going to be going ahead as a small First Nation of 400 people, and that's not my First Nation, I'm working for these guys. There's 400 people living on the community. They were first contacted 5 years ago when there was the first feed-in tariff, or it might have been one of the ones preceding the feed-in tariff. These developers would come up and say, we see that you have all this wonderful land, there's lots of wind. We're going to give you $3,000 a turbine to put turbines on your land. And we'll write that check, we'll build you a community hall, and you look at 100 turbines, $3,000 a year per turbine, there's $300,000. That's pretty good. Well, we're looking at right now a net income of about $20 million a year to that community because they held their own. They said to the developers, this is our project. It's not your project. This is our project, and we're going to let you in if you can fit our parameters. And that's what we've been doing since day one. We've stuck by that. We had a very principled approach to how we deal with developers and how we deal with the OPA and how we deal with the government. And finally, today, we've seen some real tangible results in a chief that had a vision, in a community that stuck behind their chief, and a development that will provide renewable energy to the grid, provide wealth to a small community, and do it in an area where everybody is behind the project. We haven't had one person come up and say, and have a picket sign or say, you can't do this here, or we don't like wind, or it's going to cause us all kinds of health defects. Not one person has come up. Everybody, including the local municipalities, have said, let's get this done. And then that's where we look at the whole thing about development that can work, development that's inclusive, development that looks after communities, but also development that understands our frame of mind, where we come from on this, and how we see ourselves in the bigger picture. And when we start breaking ground, it's going to be done with a ceremony. It's going to be done with a ceremony that's going to be indicative and appropriate to the development that we're doing. And that was there from day one. And it's always been there. And I also have a big smile on my face because I'm going to get a paycheck next week for the first time in 5 years on this one. And so is everybody else. and it's great. And there's nothing wrong, and I taught a business class up at the Union of Ontario Indians a number of years ago, and I had signs all over the room. One of the signs said, "Profit is not a dirty word, wealth is okay, and let's do it." So, so in many respects, let's do it, but let's do it right. Thank you very much.
Thank you, John. Thank you for the context you've given us in terms of resource development on First Nations land and within First Nations communities in Ontario. We will now go straight to the rest of the panel speakers, who will discuss litigation as a vehicle for regulating resource development and the Keewatin lands case, and also about specific resource projects in Ontario. Welcome, Sherry. So I would first call on Mr. Robert James, please.
Thank you very much for having me here today. And so for those of you who don't know me or haven't had a chance to read the biography, I'm the lawyer who worked with the Grassy Narrows First Nation on the Keewatin litigation. And that piece of litigation has been through trial, where we were successful. It was at the Court of Appeal, where we were massively unsuccessful. And the Supreme Court of Canada heard the appeal last May just passed, and we will wait to hear. So I'm not actually going to say a lot about the results, since there are no results really to comment on that case. I will say, though, is that it has been one of the great honors of my career to have the opportunity to work with Grassy Narrows and the Anishinabek of Treaty 3. And even though I've been working in Aboriginal law for close to 20 years this year, there were an amazing number of things that I found out in working on this case, and a number of insights that I did not expect to have. And I hope I'll just pass some of those along to you today. So the Keewatin case is primarily actually a relatively narrowly focused case. It actually ties to the question around the process of that John referred to of how land stops being land where there's treaty rights and becomes land where there isn't treaty rights. And more narrowly, it was focused on the question of what role does the federal government and what role might the provincial government have in that process? Is it a process that's entirely in the hands of the province, or does the federal government have a role to play? And those were the issues that were before the courts, so far at least. And the trial judge said that it was the federal government that could limit the treaty rights, and only the federal government that could infringe. And the Court of Appeal said it was the federal government that could limit the rights, and we didn't have to worry about the question of infringement because of that. And so it's off to the Supreme Court of Canada. But I actually think that the more interesting part of the case, and oddly enough, a great deal of the discussion at the Supreme Court of Canada was about this, actually had nothing to do with the issues that were squarely posed to the courts, these jurisdictional issues. But instead were about what's the larger question behind what the Crown has to do in taking up land. What is the obligation of the Crown? What is the relationship between the Crown and the First Nation? What are the First Nations' legitimate expectations? What was expected at the time of the treaty? What was actually discussed at the time of the treaty? And as a part of dealing with these sort of dry jurisdictional issues in the courts, we actually had to dig into some of those issues and touch on them, although in a half-baked, light kind of way in the end. And it's those issues that I want to talk about, because whatever the outcome at the Supreme Court of Canada, win or lose, and is that these are going to be the interesting fights in the years to come, and they're going to be at the heart of the question of how are resources developed in Ontario, and what reasonable expectations can the First Nations have of benefiting from that development. That's something that's not going to go away no matter what happens in the case. Indeed, the primary pitch of both the federal government and the provincial government at the Supreme Court of Canada was that, look, all of this should really be dealt with in the context of consultation and the Mikisew duties and the Haida duties, and that fundamentally we don't need these exotic jurisdictional doctrines lying around It's more sort of let's get on with that kind of direct engagement. Now, I suspect that the government has a fairly different view of what's involved in consultation than the First Nations do, and that's something that I'll now talk about. So, one thing that anybody who's going to deal with any of the numbered treaties or the Robinson Treaty should deal with. So these are the big treaties that start once you get up around the Sioux and head all the way over to the British Columbia border. They actually go a little bit into British Columbia and then up into the Northwest Territories and Northern Ontario. So there's the 2 Robinson treaties, and then there are 11 numbered treaties. The one book that everyone should read, even though it doesn't have any great narrative to it, even though it's actually a hodgepodge of letters, transcripts, notes, personal reminiscences, and wishful thinking, is Alexander Morris's book on the treaties of the Indians with North America, of Northwest Territories in Canada. And what's interesting about that book is that there's an amazing collection in there of both the treaty documents and then on the other hand, what was actually said at the treaty negotiations. And if you read these two things, it's actually an interesting tension. It's pretty hard to reconcile the two, fundamentally. Most lawyers are quite familiar, if they're working this area at all, are quite familiar with the treaty texts. And they're relatively straightforward. They say, this matches up with what John was describing, they say, hey, you sold the land. You've ceded, released, surrendered the land, and we're going to promise you these great rights that you have to use the land until we decide to use the land otherwise, which I've got to say on the list of rights to have is not a great right. But that clearly presages a vision of land slowly but surely being used up, land slowly but surely being put to use by non-First Nations people, put to economic development, being settled, used for mining, lumbering, wind power, whatever. Now, then you read the texts, read what actually happened in the negotiations, and there is an amazing thing. You can read them from front to back, and you will not find the words sell, surrender, cede, release. You'll not actually find the words taking up. What you will find is a very interesting contrast. So, and I'll use the Robinson treaties as a first example. There, because of what the government described as some unfortunate meddlers from the South, the Aboriginal people had a big idea about the price. And they said, look, we know that you're paying this much per acre for treaty land in the South. And what the government said back is, wait. These are not like the surrenders in the South. You're actually going to keep your lands after we buy them. You're going to be free to use them as before. We won't use anything. In fact, you're going to be better off because there'll be places where you can sell your game. So we can't give you that kind of price for that land. Likewise, when you move out into the numbered treaties, and I think this is best seen in Treaty 6, much the same language is used. And there's a great speech in the Treaty 6 negotiations where, I can't actually remember if it's Morris or Mackay, I think it's Morris, gives what I've called the Great Road speech. And he describes each of the numbered treaties, and it's the treaty commissioners walking along, taking the, of course, as they say in those days, the Indian subjects, the Queen's Indian subjects by the hand, where they're going to walk together to this great future of prosperity, and where they give up nothing, but in return get the Queen's bounty, the treaty annuities and such like in return. That they'll have their hunting and fishing as before, they'll have their rights to use the land as before. Not a whole lot about surrender, cede, give up, those kind of things. And I got to say, I was the normal skeptical lawyer going into these discussions because I've heard a lot about, there was no surrender. But fundamentally, you cannot read these documents and not come to the conclusion that on normal terms, if you saw this as somebody presenting a contract to a little old lady who didn't speak English and asking them to sign it after a certain discussion, you'd call it fraud. Like, there's just not a match between the speeches and the documents. But what's the solution to that? And actually, I think the Supreme Court of Canada is alive to that. And in a sense is what they've said as well, we're going to hold the government, using this honor of the Crown's concept, to to what we delve into as the understanding. And to some extent, the Grassy Narrows case is about the understanding of who the treaty is with. And we'll see what the courts say about this. But the more important question that lies behind is going to be the question, to my mind, of was this really such a complete outright surrender or sharing of the land that the lands can be just taken up and used and put to the uses by mining companies, forestry companies, for settlement, without any real input? And by real input, I mean more than just a visit, a chit-chat, and being told we're thinking about your thoughts with the First Nations. And to my mind, you know, whatever the story may be in Treaty 8 country, where Mikisew was decided, in the Robinson treaties, in Treaty 3, and in Treaty 9, it's very hard to arrive at any conclusion other than what Justice Sanderson arrived at, which is that when the treaties were made, there was a real expectation that, yes, the white man would be arriving, yes, there would be development, yes, there'd be resource extraction, yes, there'd be all kinds of things, but that there would be mutual benefit in this, that this was not a one-way street where we would slowly but surely see the land chewed up and Aboriginal people limited in their pursuits and their interests, and limited in time as well as place. In fact, everyone expected that there would be a bright future ahead and it would be a shared future. Hasn't quite panned out that way. And I don't think anyone can realistically look at the situation in Ontario and say that it has panned out that way. So where do I see the future? I mean, the future clearly is in approaching this problem as a means of we've got to find a way, and I mean the non-Aboriginal community, of actually engaging with the Aboriginal community in a way that recognizes the actual discussions that occurred, that recognizes the actual expectations, which means reaching an understanding about what the limits on development are, and then also reaching an understanding about what the sharing of benefits are. And that this is going to be something, I mean, we're hearing here, I think, about an impacts benefit agreement or about actual participation in a project. But on many of these things, this is something that's going to involve the governments actually being at the table, as there are many issues such as revenue sharing and the management of cumulative effects, which frankly cannot be dealt with at a company by company process. I think it's a bit unfair, both the First Nations and the companies, to expect them to sort out a problem that is really a larger societal problem, and one which is going to require engagement by the governments. So what are a few of the hints that I would say? So first of all, and now I'll put in a little pitch for lawyers here, although we do like to be paid. So first of all, when you look at British Columbia, Alberta, Quebec, where we see the impact benefit agreement and also the reconciliation agreement process the most advanced. I mean, look at the Haida agreement or look at the James Bay Cree agreements, and you'll see something that's really not known in Ontario. I hate to say it, that First Nations have to defend their rights and defend them in court. These things have not happened because of the fact that manna has fallen out of the sky. This has happened because of the fact that governments and companies have realized that there's a cost to not reconciling with Aboriginal people. And look, we live in a democracy. Governments are expected to justify expenditures. They're usually not justifiable, I hate to say it, on moral grounds. Likewise, company shareholders expect expenditures to be justified. And one of the best justifications is, well, the courts have told us we have to do this. The second thing I would say, in my 3 minutes remaining, is that big imaginative solutions require political engagement at highest levels. Both when you look at British Columbia and Quebec, where I think we see the best examples of this, what we see is premiers and ministers taking hold of these issues and making them a priority. That doesn't mean that they're down negotiating at every meeting or attending every meeting or reading every jot and tittle off a document. But it means that they are sending the message down through the bureaucracy and out to proponents that you have to deal, and this is a priority, and I want to see this happen. Is the deals at Haida Gwaii, the arrangements at Musqueam, the arrangements in northern Quebec, were all made because political leadership directly engaged in this and didn't just sort of hope it's all going to work out. And my final comment, and this may be a bit controversial in light of what's going on at the AFN right now, is that the governments need to support the development and strengthening of Aboriginal organizations and First Nation governments. The way these deals happen and are accepted by the community is when they have strong governments and representative bodies standing up for them, so that the community has the sense that this is not something that's just been imposed upon them because their community is out of money and can't find volunteer lawyers and public relations consultants. The reality is that, that where we see deals being reached, and again, I'll hold out the Haida as an example, but there's hundreds of other examples in northern BC, northern Alberta, and Quebec, and in Labrador, are where we see strong Aboriginal organizations that have the resources, the recognition, and the ability to engage with the government and then also engage with their community. Because ultimately the success of any of these arrangements depends upon grassroots and membership buy-in. And when we look at what happened with the Northern Gateway Project and some of their agreements in the Wet'suwet'en and Gitxsan territories, where there were agreements reached with the organizations, but the organizations were unable to engage with the communities, we quickly saw them fail. We essentially saw uprisings against the leadership. And in the end, success is going to depend in the long run, as these problems get harder and more difficult, on there being somebody to answer the phone when the government calls or when a company calls and says, we have an idea. And trying to put together an organization at the last minute because there's a crisis today that needs to be dealt with is not the way this is going to work. So I've now used up an extra minute of my 50, and so I will now get out of the way. Over to you.
Ms. Brent.
Thank you. Hi, everybody. So I'm going to pick up on a couple of points that you made because my presentation lines up as well. So, Robert, you mentioned that First Nations need to defend their rights and defend them in court, and that we need strong representative bodies and in our governments, and that we also need grassroots activity to take place. What I was going to talk today about is take us back a bit to what's happening or what's happened in Ontario back starting in 2006 with Ontario's provincial planning process in electricity regulation. And as we'll see through my presentation, those are actually the things that were put in place in order to come up with the tools that we find for resource development and renewable energy development in Ontario. So let me start with the Ontario energy planning process. So some of you may be more familiar than others, but back in 2007, the OPA filed an application for approval at the Ontario Energy Board called the Integrated Power System Plan, or the IPSP. Now, this plan was a massive document that addressed all of energy infrastructure in Ontario, and it considered supply and demand as well as conservation processes for Ontario, and it set targets and goals for development for the next 20 years in Ontario. And the plan was supposed to be updated every 5 years. The IPSP contemplated strategic planning processes that would impact Aboriginal and treaty rights all across Ontario. Now, back in 2005, an organization had formed, and several other First Nations were already becoming interested in the idea of renewable energy development. In fact, there was other First Nations that had been involved in renewable energy development for maybe 10, 15 years prior, a community called Pick River in particular. But anyway, back to 2005, there were communities that came together and formed an organization called the First Nations Energy Alliance. And this was a group of about 16 First Nations, all located around Georgian Bay, up to including Pick River and down including some communities like Walpole Island First Nation. So this was a grassroots organization. So to your point, this was a group that came together on a grassroots basis. They recognized that there was going to be an immediate impact to Aboriginal and treaty rights, And there was a planning document, several volumes, that indicated how Ontario would move forward and develop generation and transmission projects all across lands that had Ontario First Nations treaty rights and Aboriginal rights in place. And so the purpose of the organization had been to come together and look at this planning process, but also try and see what the opportunity would be to look at promoting economic sustainability through the exercise of Aboriginal treaty rights. So the FNEA took part in the IPSP planning process, and what that was a planning approval that had to come before the Ontario Energy Board. And so to your point, Robert, on a court process, this was a regulatory process, an Ontario Energy Board process that enabled First Nations and other interveners to participate and have their views known and brought forward to the table in an approval process. And so this was also a key piece of the puzzle that was unfolding. And so you had this grassroots group, and you had this regulatory process taking place, and several other First Nations, other groups, were also intervening. And so it quickly became evident to several First Nations that the IPSP presented an opportunity, but it also presented some serious potential impact with generation projects and other resource projects, some that would be taking place up in the Anishinabek Nation territory, up in a large project called Little Jackfish. There was another project, there was the North-South Tie, a very large transmission project that was proposing to consider large upgrades of transmission from north to south, as well as other projects around the Bruce Peninsula that were planned. Now, I mention all of this because it's with this backdrop that the province and the OPA ended up putting in place a provincial procurement mechanism. And so at the time, this was really fantastic. This was sort of a door was opening for all those First Nations that had participated in that grassroots process, that had made their views shared, that had also enlisted the assistance of their political territorial organizations to put their views heard in this regulatory process. Now, the IPSP had, or I should say, there was a ministerial directive that came down in 2008 in September that had put the brakes on that process. But what was fantastic was that the directive also contemplated that further engagement had to take place with First Nations, and that the OPA would be directed to find mechanisms for First Nations to participate in generation and transmission in Ontario. So from a First Nations perspective, the communities could not fathom economic development taking place all over Ontario where their treaty rights would be enjoyed without their full participation. And so this outcome was seen as a positive move. Now, the government recognized this and created this process and enlisted the OPA to come up with an engagement process for First Nation participation. But it really required a tremendous lobby effort on the part of First Nations and their representatives. And so I think it's important that we look back at this process because it's an example of how advocacy was required at the Ontario Energy Board and at the ministerial level in order to promote change. And so I think that dovetails with your comments on how important it is for First Nations to continue those grassroots efforts or to reinvigorate those processes. So, I'm not sure where I am with my time. So now we're up to 2008, and the OPA has been put back to the drawing board, and they've put in place a FIT procurement program. And so this is a standard offer contract program that would enable First Nations participation and Métis participation in these projects. And so in 2009, the FIT program was launched, and several First Nations applied. One of the communities that was successful was Chiging First Nation, Susan Hare's community, and it was through the leadership of Chief Hare that promoted the idea for Chiging to participate in this process. And so the rationale for putting the FIT program in place was also to create a program that removed barriers to participation for First Nations. And so it was a specific policy agenda to address the difficulties that First Nations had in competing in resource development projects. And so Chiging was awarded its FIT contract in 2010, and they moved forward and they completed their project, and this really created an incredible catapulting and opportunity for the community to have its own internal capacity building. And there was a champion of that process was Grant Tabosky, an economic development officer there. You know, the community was really able to take on that project and really learn how to carry out commercial development under this program. Now, I mention all of this because at the time, what was being done was tools were being created and barriers were being addressed, and there was some real attempts to focus on promoting sustainable development for First Nations. But this was all actually really being done on the basis of focusing on what is the most practical solution, what is the most practical thing that we can do right now. And communities were looking for access to capital. Communities were looking for access to their own source revenues because budgets are limited and communities really need to find ways to create sustainable revenue streams. And so there's a lot of practical need, or a lot of immediate needs, and the need for practical solutions. So while that's important, I think it's now the time that we actually dig deeper and that we move beyond looking at these practical solutions, and that we start to see that what we had and what had been created was a great policy outcome, but it was not a legal outcome. And it comes back to what Robert was saying. So I've participated in the industry. It's my practice area. I see all the benefits, and Chiging is one of the many benefactors, and we're going to hear about some other First Nations, and we know that Henvey Inlet is soon to be another community that's going to go down that great capacity building process. But I think we really need to go beyond practical solutions and start digging deeper into some legal solutions and into some structural solutions that have greater meaning than policy. What we've also seen in the times past is that government policy can change, and that government policy, it's even happened specifically in the FIT program that was designed to create that solution. There's been case law where the government's been able to just, change their policy, and that really pulls the rug out from underneath the intent of an accommodation for First Nations and their Aboriginal and treaty rights, and their intent to have participation and full participation and revenue sharing in the economies that take place in Ontario. So I'm really honored to be sitting with you today, and to also know that Grassy Narrows is moving forward with this case, because it really is important that other communities are pushing forward for strict legal rights. And my practice is focused on the practical solutions, as I say, but we really need the people that are going to be pushing for the tough legal solutions. And I think that's really our future, and it really requires as well government to recognize that, a policy sometimes is just not going to be enough to address these issues. And I can really sort of see, we've seen how it's being pulled away, and so government should also move the bar too and look to find some real structural solutions. And I don't really think that allowing communities to have their own IBA negotiations on their own is going to be the solution either. Thank you.
and thank you very much for attending today's session. I'd like to first acknowledge the work that Robert and Cherie have been doing on the legal side, and some of you as well, in working for Aboriginal communities. For the work that I do on the development side could not happen without your efforts. So again, I just want to thank you very much. Despite the challenges that we have heard about, I think it's important for us all to realize and acknowledge the successes that have been to date by some of the First Nations, and moreover, it's happening for more of them as we speak, particularly for those communities that are willing and able to commit themselves to the lengthy time frames, sometimes 4 to 8 years, required to bring these projects to fruition. If I may, I'd like to describe to you today some of the highlights and ingredients of success of a very recent First Nation success story in the renewable energy sector. And by doing so, my hope would be to help others formulate a repeatable blueprint for the successful development of First Nations or Aboriginal-owned resource projects. The story I'd like to speak to you about today is the Rainy River First Nations solar project, situated in northwest Ontario, approximately 415 kilometers west of Thunder Bay. This 38-megawatt project, when operational in early 2015, will generate enough green electricity, green energy, to power over 3,900 homes. My company, Cedarvale Energy, is the development partner for this project, and the $175 million financing, which recently closed, was arranged by Cox & Rowe Capital Corp., of which I'm a director. With reference to my mention of lengthy timeframes for project development, this story actually began in mid-2009, when my partners and I decided to set up a company called Cedarvale in response to the introduction of the Green Energy Act and the Ontario Feed-in Tariff Program. Upon examining the program and the Green Energy Act, it became apparent to us that through some of the elements of the FIT program in particular, such as the Aboriginal Price Adder and the Aboriginal Loan Guarantee Program, the province was making a concerted effort to encourage and incentivize First Nations participation in the green energy sector. We also concluded, with our investment backgrounds and development background, that First Nations ownership of renewable energy projects under the FIT program would provide these communities, most importantly, with long-term stable income to support economic development initiatives and improvements in community services. Our primary objective in setting up Cedarvale was and remains to help First Nations communities participate in a meaningful way. And by that, I'll mention that Rainy River First Nations holds a 51% or major majority interest in that project. In the early days, when we got started, we were very fortunate to have received much guidance from Elder Rod Meneg Sr., Beausoleil First Nation's longest-serving chief. During our many long drives up north with Rod to visit various First Nations communities, we'd enthusiastically absorb everything Rod told us. From the broad diversity of issues that he dealt with during his 22 years as chief, to demonstrations of what to do during a smudging ceremony, to present to benefits, how to present the benefits of green energy projects to chief and council, and so on and so forth. During this time, we also learned a great deal about community consultation and the role and its importance, particularly in communities with trust funds established as a result of land claim settlements. Sadly, Rod passed into the spirit world on January 5th last year, but the knowledge and wisdom he imparted on us will never be forgotten. By the fall of 2009, we were working with 5 First Nations communities, and in each case, our company was responsible for conducting pre-feasibility studies in completing and submitting to the Ontario Power Authority on behalf of the communities FIT applications for on-reserve utility-scale solar projects. Unfortunately, most of the large developers had moved first and had already submitted FIT applications during the initial program launch, which ran from October 1st to November 30th in 2009. Fortunately, this also meant that there was no connection capacity remaining for our First Nations applicants. At the time, we decided to go back to our First Nations partners and test their commitment to securing a project opportunity through an acquisition strategy. We were very upfront with our partners and had told them that an acquisition process could easily add a year to the overall project timeline. Only one community, Rainy River First Nations, agreed to move forward with this strategy. With a clear direction from the chief in hand, we reviewed the OPA's list of FIT contract awards and discovered that 3 FIT contracts had been awarded to a developer that actually held options to lease private lands located in Rainy River's traditional territory. Shortly thereafter, we opened up discussions with the developer to inform them of our interest in purchasing FIT contracts. Ultimately, on our initial approach, the developer decided not to entertain our offer to purchase. However, we pursued, and 1 year later, after changing circumstances for the developer, we were back at the table, this time in serious negotiations with our partner. First challenge we and our partner Rainy River faced was that what were we going to pay for 3 FIT projects? What were they worth? In order to determine answers to these questions, we worked very closely with industry experts with as much accuracy as possible to determine the total cost to construct and finance these projects. As it turned out, we were quite fortunate that our estimate was within 0.1% of the final project costs used for project financing purposes. And once we determined these costs, we entered them into our project financing model to determine expected investment returns. Through extensive scenario analysis with Rainy River and many meetings, we were able to determine the maximum price we were willing to pay for the projects. This analysis was then packaged up in a form that was easily digested by council members with little financial background. Suffice it to say, there were a number of complicating factors, as there usually are in these types of deals, surrounding the acquisition, which we eventually resolved by July of last year when a definitive purchase and sale agreement was signed. It's worth noting that this acquisition process alone was almost 2.5 years in length. Immediately after that, we began a detailed market evaluation of potential project constructors, key equipment suppliers, and project finance lenders. Again, we worked very closely with Chief Leonard throughout this whole process. And in fact, the Chief and his band administrator had been intimately involved from the beginning, attended every single site visit that we made to solar projects that were under construction, and also made all the due diligence trips to the manufacturing sites of the key equipment suppliers. This level of involvement by a First Nation partner is critical as it builds a high level of familiarity with the key elements of the project, which in turn becomes of critical importance when key decisions need to be made by the partners. The second major challenge we faced together was how we were going to select the best constructor for the project. And after a number of discussions together, we developed a simple and effective framework for the evaluation and selection of a construction partner. It's worth noting that we were able to draw on much of the collective knowledge we'd both accumulated during our visits to the solar project construction sites belonging to other developers. Our collective experience told us that our chosen constructor must have an integrated engineering capability and must possess the capability to self-perform most of the assembly and installation work. As it relates to the financing of the project, there were some unique issues that had to be carefully addressed early in the process in order to ensure a successful project. First, in our case, our First Nations partner funded its equity contribution through a trust fund that it established in 2005 to manage funds it had received from a land claim settlement with the federal and provincial governments. My advice to you, if you are involved in a project seeking monies from a community trust fund, is to start this process early. Well, community trust funds regularly provide funding to the community. A request to fund a complex, multi-million-dollar, in this case, $175 million project, it's seldom seen by the trustees. In our case, the trustees of the trust fund hired an advisor to conduct the due diligence on the investment proposal to ensure that it was consistent with the objective of the fund as set forth in the trust agreement. The advisor turned out to be one of the large accounting firms, and Cedarvale prepared the trust application and the supporting material, which included a 30-odd page business plan and a 16-page financing plan for the solar project. The advisor was given copies to review all the material contracts plus the financial model, and after several conference calls were held to answer questions to the advisor, because the request exceeded a certain dollar amount, the community also had to hold a vote to approve the use of the funds. So my point here is that in addition, the time and effort needs to be devoted to this shouldn't be underestimated. It's really important in terms of everything else that's going on in the development and the development phase and project financing phase. Another unique issue relating to the financing was the discussion and negotiation involving the rights of the project owners to sell their position at some point in the future. And what's unique about this is the fact that if Rainy River were to sell its position, the project would lose a significant revenue stream due to the removal of the Aboriginal price adder. Additionally, the non-Aboriginal owners, representing 49% of the project, were concerned that if Rainy River were to sell its position and then sometime in the future, perhaps under a different chief, decide that the community wanted to receive financial benefits because the project's located in their traditional territory, could expose them to a dispute with the First Nation community. These issues were eventually solved with some concessions on both sides. I'd like to talk about a couple of additional factors that played heavily into the successful First Nations project, which is capacity and cultural competence. Talk about the capacity in the context of a resource project. The capacity in this context refers to a First Nation's ability to dedicate one or more capable individuals whose responsibility it is to attend on a timely basis to all project-related matters. Such matters may include developing and implementing a strategy for effectively communicating project-related information to chief and council and community members, approving or seeking approval for project development expenditures, and liaising with trust fund trustees and their advisors. It's critical to the success of the project that these formally appointed individuals possess basic knowledge of financial concepts and have some administrative background. In the context of a resource project, capacity also comes into play during the construction and operations and maintenance phase of the project life cycle. Most First Nations partners see these types of projects as an opportunity to acquire skills the community does not currently possess. And for this reason, there's always plenty of discussion around the structuring of the construction contracts and operations and maintenance contracts, in a manner, of course, that ensures the First Nation community that they'll be provided with adequate opportunity to acquire these desired skills over the life of the project. Suffice it to say that careful thought needs to be given to contract language in this regard to avoid any undesired incomes or abuses of such provisions by the parties to the contract. In a broader sense, capacity building refers to a process whereby First Nation community acquires over time specific skills and expertise required to achieve economic independence. This is usually accomplished through the creation and spawning of local businesses, generating a steady stream of profits for the community. Some First Nations now face moral dilemmas in that monetary returns from resource projects can be so large relative to government transfer payments that the community is suddenly faced with major decisions on how money should be responsibly managed. For example, one First Nation community is considering allocating funds to substantially expand its on-reserve housing in an effort to attract off-reserve members back to the community. While the expertise required to develop an integrated social plan, including health care, social services, education, etc., can initially be contracted out, over time it's critical for the community to build its own expertise or capacity in this regard. Doing so will ensure a greater sense of community. With respect to cultural competence, it's a matter of mutual respect, in my opinion. In order to form a trusted and lasting relationship, a basic knowledge and understanding of your partner's culture is an absolute requirement. It's most easily gained through physical togetherness and asking lots of questions. This kind of learning can also be enhanced through reading some of the material that Robert referred to earlier, attending relevant cultural events as well. Other than the few unique issues that had to be addressed relating to the First Nations ownership, the project development and the project financing proceeded as any other project would. In the end, we, that's Rainy River and Cedarvale, were successful with this project because of the way we, because of the way the softer issues were attended to, as opposed to the simple mechanics of closing a transaction. In summary, the key ingredients for a successful partnership with an Aboriginal or First Nation community are, first and foremost, cultural knowledge and appreciation. Respect, compassion, and understanding have little foundation without these. I would suggest becoming familiar with the history of treaties, as we talked about earlier in Canada, talk with elders, chiefs, and other community members about life on a reserve, or what it's like to attend a residential school. Attend ceremonies such as powwows and other social events such as fish fry. Common sense. The second recommendation or ingredient for a successful partnership would be to maintain constant communication and a physical presence. It's difficult to understand each other without this. Set up regular conference calls with defined agendas, prepackaged meeting materials, and ensure that at least half the meetings are conducted face-to-face on or near the community itself. It's one of the most important things. Also, establish a win-win philosophy of teamwork. Set mutual goals and work together to achieve them. And don't forget to celebrate the wins, no matter how small. And last but not least, I mentioned some of these long time frames over which these projects take to bring to fruition. Patience and determination are essential on both parties to achieving success in resource development projects. Again, they can take 4 to 8 years from start to finish. This isn't always attainable because of the First Nations 2-year election cycle. So it does take a concerted effort on both parties. Closing, I'd like to say that notwithstanding that the FIT program for large renewable energy projects has been terminated, we're still very optimistic about the future as it relates to First Nations Aboriginal ownership of large renewable energy projects. As most of you probably already know, the provincial government announced earlier this year a new procurement program for these large energy projects. With the new Liberal majority government in place, we can now be confident these programs will thrive for at least 4 more years. And that's enough time to add a few more First Nations Aboriginal green energy projects to the growing base in Ontario. Thank you very much.
Thank you to all the panel members. Thank you, Sherry, Scott, Robert, John. That was, you're lucky I can't ask questions because I take up all the time. We're opening the floor now to questions from the audience, and As most of us are lawyers, we have a couple of rules. One of them is one question each, and each question has to be aimed at constructive dialogue. Okay, the floor is open. There's 2 microphones on either side, so come forward.
Ms. Brandt, you mentioned Grassy Narrows just in passing at one point, if I'm correct. My hearing isn't great. And everything I've heard in this panel has been very positive about First Nations working together with companies for resource development. But the only mention over the years that I've been aware of Grassy Narrows is the people being victimized by logging operations. Is there a complete dichotomy between certain companies coming in and treating the people with a lack of respect, but somehow when energy generation is the issue, there is mutual respect? Can you help me a little on that?
Sure. Okay, well, I mentioned Grassy Narrows on the basis that I was referring to the importance of maintaining litigation and maintaining the concept of fighting our battles in court. And we know that in the Keewatin case, that's what's happening, and that's an ongoing case. And so, but my comments were referring to the positive sides on practical solutions for promoting resource development. So I think, you know, with renewable energy, the experience, and we've heard with Scott, the experience, there is a lot of positive stories. And from my perspective, when I came into the industry, it really represented one of those areas where we could so easily create a real difference, because First Nations have so much land and First Nations have so much of an interest to promote economic development, and renewable energy is, you know, it requires a lot of lands for development. And so there really was a natural synergy there. And so I think that's why renewable energy and First Nations have started off on a good track. But I mentioned earlier in my presentation, when the original planning process that was happening in Ontario started to was commenced, it really required First Nations to step up and make their interests known. Had they not come forward and not taken that grassroots approach and not had an organized approach, in fact, there were several organizations that came forward as interveners as well, we wouldn't see the programs that we see now, and we wouldn't see the government procurement policies that are so positive and that create incentives and bring companies and First Nations together and companies and other Aboriginal groups together. So I think there's a lot of good things that are happening in renewable energy and resource development right now. It would be great to see that happening on other fronts too, in other forms of resource development. But I mentioned Grassy Narrows because it's important for those cases to continue.
Before you ask, could I just add something to that? Just from the Grassy Narrows perspective, I think that the renewable energy, and this is really a bit of a reiteration, the renewable energy example shows a way in which the government can help make it work, in that there is actually a benefit that the First Nations can bring to the table because of the way that the overall system ended up working, where essentially they have something to market to the companies. So there's actually a mutual benefit there. I mean, outside of that situation, and there's numerous situations like that, the other tool First Nations have is essentially what we jokingly call in my office is the process of making life a living hell for the company. So it's having a hard job getting its projects approved, which usually, like if you're talking about an oil sands project where you might have $100 million in capital tied up for a year, that's a big expense. So that gives an incentive to companies to deal. But that leads to very spotty results because it depends upon the First Nations' ability to put up a fight. It depends on the legal system in place. It's a much, and it tends to lead to a lot of bad blood, which takes a long time to cure. And then there's other situations, and forestry is a particularly good example where margins are very low in the companies. They often have legacy licenses, although no longer in the Grassy Narrows situations. And so there's very little incentive or ability of the company to compromise, so it tends to become war, which is more or less what happened in the Grassy Narrows situation.
Thank you. Liz Jordan, please.
All of the panelists talked a bit about the need for strong First Nations government if you're going to partner in projects. And Robert and Cherie, you've both talked about the importance of First Nations litigating to protect their rights if necessary. But those things require resources, and we are in an environment where the federal government is not necessarily interested in providing resources for those things. And I'd be interested in hearing the panelists' thoughts on that. Thank you.
Cherie first.
Sure, I'll jump in. So I guess in view of your comment and the obvious recognition, we're not going to end up in situations that easily where governments are cutting checks to First Nations, and we do need to find ways to move the bar. And I think, from my perspective, I think there's still a lot of things that government can do outside of litigation, and that moves beyond the current policies that we have and the current government procurement policies that we have. So I believe that the government procurement is great, but I think we need more. I think we need to have different governments coming together, different groups of First Nations coming together with different ministries and putting in place co-development processes, and that could actually create something substantive and something different and move the bar. And so I do recognize the issues and challenges that we have with litigation, but I think it's important because it keeps the dialogue, it keeps people questioning what our relationship is. But I think the intermediary piece is to come up with some co-management opportunities and come up with other ways circling around allowing First Nations to have meaningful participation in resource development and meaningful participation in resource stewardship.
Mr. Beaucage can answer part of that question as well.
Yes, thank you very much. And I spent 12 years as being a political person within the First Nation milieu. And basically, I learned very quickly that government is there to look after government. And they're not there to look after Indians. They're not there to look after our rights. They're there basically to make sure that there's a lessened liability on the part of government for any sort of action. If we press them into a process where litigation is required, they're going to come in kicking and screaming. So we have to find other ways to push the issue, and part of that is to create wealth in some ways with ourselves, so that we can some of our wealthier communities can make use of that wealth to push some of the issues on rights, and other times it's just a poorer First Nations getting together and cobbling what they can, and with the help of some of the legal minds in the country to go ahead with things on litigation. I myself was part of a case that went to ask for leave to appeal at the Supreme Court. We didn't get the leave to appeal, but overall, it was a small First Nation that was working on a land rights case, and it cost us about $900,000. And we worked really hard to pull that money together for the whole time of the litigation, and we were paying for it even after a few years after the litigation was closed. It is really difficult, but governments always seem to be there at some point, because in my mind there is a caveat on all the lands across Canada, that there is nothing free and clear in terms of ceding and absolving ourselves of any title to land across Canada. And as long as that caveat is there, I think that the governments will have to be involved at some point, because there's no such thing as clear and open title and clear patent on any land. So as you develop lands, as lands are developed, consultation and accommodation become key, and any time that there's a possible infringement on our treaty rights, they have to be involved, and we have to make sure that we have the appropriate legal minds to help us form that argument.
So can I add something
Sure.
to this?
Go ahead, Mr. Jen.
I think it's important to keep in mind that there's a number of techniques that can be brought to bear. I mean, on the litigation side, obviously one big thing I believe in, although it doesn't seem to work out that often, is try to find small manageable cases to make a point, right? Don't try to litigate everything at once. In some cases, let's say when that fails, there is the advanced cost order case law developing. But actually I think, and an experience I've had recently on the Northwest Coast has really driven this home to me, is that what John says is critical is the point about wealth development in First Nations, and you just cannot focus only on one thing. So for example, I work for a First Nation where over a number of years they have developed capacity in construction. They're situated on an island probably 90 kilometers to the west of Prince Rupert. They are as close to being in the middle of nowhere as you can imagine, but they've developed a very active construction company in Rupert, and they have, through a series of IBA agreements and ordinary commercial agreements now, bring in tens of millions of dollars a year through that company. And what that's allowed them to do is that they have taken a very hard position against the Northern Gateway project. And because of their revenue from that company, they've been able to invest money in, putting forward a very fulsome case before the JRP, have a very complete record for the purposes of any of the appeals. So it's really, when you look around at and I'll talk in the West because that's what I know the best. When you look at nations like Squamish, Songhees, Lillooet, Mikisew, ACFN, they build their economies at the same time as they're deciding on strategic litigation. The two feed each other. Now, I do think the federal government's going to make things worse soon, because they are, and again, this is causing a lot of consternation in the nations that have extensive IBA arrangements. I mean, sort of following the Alberta model, they seem to be moving towards a required disclosure of IBA revenues to the federal government. And what many of us suspect that this is a first step towards sort of an across-the-board application of the own source revenue deduction as against transfer payments. And I can tell you there will be hell to pay, if that happens. But in terms of setting back, what has been a process which in British Columbia at least has led to some positive developments, it will be a huge setback in First Nations government relations if Canada goes that direction.
Okay. Any more questions? Oh, see someone. Oh, okay.
I had a question about treaties. When you talk about how it's surprising that there's no talking about ceding or selling land, when does it become you can't approach treaties and agreements through your Eurocentric view? Because as First Nations, we don't feel that we own the land. So when you signed a treaty, it's not an acknowledgement that we're giving you the land for something. It's an acknowledgement that this is a land that we all belong to, and we're acknowledging that you're here. So moving forward as a First Nation, my community was one of those people holding up the signs, protesting, saying, no wind energy, because there's a feeling that we're not part of mutual respect. It's you coming to our communities with a deal, and we have to somehow accommodate you. I don't think that that's an equal relationship when you're benefiting financially and we're taking on the risks and getting jobs, getting trade skills. There's inequality there. And how do you address that?
Mr. Frazer?
It's a very good question. I think a lot of it's just got to do with mindset in a partnership, and certainly when we approach First Nations, we don't go in as we're going to make all the money and run away. It's very much a partnership. and we strive, first of all, we spend a lot of time trying to understand exactly what it is.
But when you say that, oh, go to a fish fry, of course, that's common sense. That sounds so condescending to me. And when you name things that are basically you're tokenizing my culture and saying that that's how you're going to be relating to me, and that's your cultural competency. Going to a smudge, going to the community, there's definitely a lack of understanding on your part as to what engagement means to me. And in terms of what you're giving back to me, to my community, trade skills, that's not enough. Construction, contracts, that's really not enough. It's like we said, when we're thinking 7 generations, trade skills, that's really not anything.
Well, I apologize if it came across that way, but what I really meant was just by way of an example, and it could be as simple as just a marriage. Getting to know that person and their particular background, if that person perhaps was from a different country, you would spend a lot of time getting to know that person's culture, and to me, that would mean spending a lot of time in their country and going with them to cultural events and all that sort of thing. So what I was really trying to say, it's about getting to know your partner and what's important to them, because one of the first things that I realized throughout my many engagements with First Nations is that, you know, unlike Bay Street here, money isn't the be-all and end-all. And that was important for us to realize, and when we realized that, all of a sudden there was a common understanding which we got to the bottom of and could set goals and objectives that made a lot of sense for the community, not just in the sense of tomorrow and a week from now or a month from now, but like John was saying, 7 generations from now, because things don't evolve overnight. Things like economic dependence and that sort of thing, it takes, in many cases, generations to achieve. And it is about, you know, acquiring skills and that sort of thing to facilitate that kind of development. So again, you know, we spent a lot of time trying to understand our partners and where they're coming from, and it's not always monetary goals.
But Cedarvale, your company, isn't making a 7-generation plan for Rainy River.
Well, we certainly sat down and discussed all that, absolutely. Absolutely.
I'm going to move on to the next question. This lady has been waiting here. Thank you, Mr. Frazer. I understand there might be some poor phrasing once in a while of an answer. Thank you. Go ahead.
Thanks for all your presentations. Sherry, you talked about the need for restructuring, and everyone here has touched on the issues of consultation and accommodation. In light of that, I wanted to know your perspectives on consent and how that can be pushed forward from here on in the legal world.
You picked a really difficult question to ask me, but it's very important. You know, for myself, I have to say, so for my practice, I've been practicing for 10 years now. I act for First Nations, and I also act for renewable energy developers. I also act for proponents that are looking to partner with First Nations and looking to build those bridges. And the work that I do is focused on building bridges and trying to connect communities with sustainable development opportunities. So the question of informed consent on projects doesn't actually come up a lot in my work, but in fact it's really the next piece. It's really the next chapter for all of our communities, and I guess what I have seen is there are some examples right now where, practically speaking, we are ending up in a consent scenario. And so I think that's kind of interesting. We have jurisprudence that talks about not permitting a decision to a consultation to create a veto, but we're actually having situations where the practical reality is that the proponents can't move forward without having First Nations on board. So that's really the next chapter, and I look forward to being a part of it and seeing how it continues to unfold.
One last question from this gentleman.
Hi, good afternoon. My question has to do, it's more philosophical than legal, but about this concept of managing Aboriginal traditional knowledge, okay? In order to engage in meaningful discussion, you know, you need to have people that understand the richness of the culture, and I refer to Aboriginal peoples. But like everything else, that culture is changing, it's transitioning, people are moving, language is being lost. My concern is that, you know, how do we preserve that Aboriginal traditional knowledge so that in the future we can engage in those discussions in a meaningful way? I'm not sure in your tenure if you've seen a diminishing of cultural appreciation for you know, Aboriginal culture. So the question is, how do you preserve that culture so as to maintain the richness and diversity of thought to make consultation and accommodation meaningful?
Mr. Beaucage.
Thank you very much. The whole aspect of maintaining the culture is so difficult. A good part of the culture is contained within our thinking and our language. And we all know that many of our languages are disappearing every year, and our language speakers are dying off. It is fortunate, though, that we have a number of young people who are now taking up the responsibilities to learn the language, to preserve the language, and also preserve the culture. Our people thousands of years ago knew that this was going to happen, and there was a concerted effort before there was even contact to make sure that that our culture and our language and our spirituality, our songs, our way of life was protected. But there's been 500 years of erosion, and I think we have elders that are saying to us to work every day at it, and I'm thankful. I've got 11 grandchildren, and they all are working hard. I got 5 of them that are dancers. I've got 3 of them that are very, very good at the language, and I never went to a powwow until I was in my late 30s. These young people are going to powwows when they're 2 and 3 years old. So things are happening, and some of the stuff is returning. Some of our cultures are returning, and our spiritualism is becoming stronger, and we, as a communities, we just have to keep reinforcing that. And God forbid that it would ever leave us, but we still have the people that are out there that are looking after it, and we have to revere those people.
With those words, thank you. I'm going to conclude this panel this afternoon, and I want to thank all of our panelists. Thank you, each of you, and as well as the audience members who asked questions, very good questions of the panel members, but it's not over yet. You have to fill out your evaluation forms. And we want you to join us upstairs in Convocation Hall for reception and a very great presentation. Thank you.